Yeah, good evening, everyone. So we will be starting with the appellate jurisdiction. In the last class, I discussed with you Article 32, and then we went on to the original suits, right? So let me just share my screen. 1 second. Okay, before we start with the appellate jurisdiction, I think we should finish off with the original jurisdiction. We have already done extraordinary original jurisdiction, right? So under the extraordinary original jurisdiction, we have covered it lies under Article 32 of the Constitution, which is for the enforcement of your fundamental rights. Likewise, you see it there in the PILs that we file. There also it comes. Then we come to a look at the original jurisdiction of the Supreme Court. Now, as far as the original jurisdiction of the Supreme Court is concerned, under Article 131, we have seen the original suit. Now, another important aspect, another important thing that we see in the Supreme Court is that your transfer of cases. Now, transfer of cases, it can be happen under various categories. Like first, if it is in a civil matter, then you file it under Section 25 of the CPC. And if under it is criminal matters, then you go for 406 CRPs. Now, this is available only for interstate transfer, because why this power is given to the Supreme Court? This power is given to the Supreme Court because again, you have to go and look upon the federal structure. One state cannot direct it. Matters should be transferred from state A to state B, right? So who can do it? It is only the apex court which can do it. Now, it is very important to know under transfer of cases, why you want to move a person from jurisdiction, why do you want to move a case from jurisdiction A to jurisdiction B, right? What is the reason? Generally, you will find civil matters coming in case of civil matters, you will find coming in case of your matrimonial disputes, like when wife says that we want to transfer the trial and court does it happily. But you have to look at the cases where you find that it is causing an unnecessary hardship to the opposite party. Like recently, I have done one case. It has come to me. I mean, it was from the Supreme Court Legal Service Authority, and this was one case where the wife has filed for a transfer petition, and I was for the husband. Now, in this case, it was a short case that in a TP, a wife transfer petition will be transferred. So in this case, what we had to do is we had to file, generally, if you say in court that I will file a response to a transfer petition, court generally laughs at you. What reply you will file on behalf of the husband. So I was also laughed and I said, Lordship, just give me a week's time and I will do it. So in that case, I was able to show to the court that this was a case where the wife has actually deserted the court. It is a case where the kids are with the husband. This is a case where husband was ready to provide her for to and fro. And then I also documented his actual salary which he was getting and his expenses. So why I am telling you is not to harp upon myself, but to give you a practical idea even for the drafting, right? Without drafting it in a way where I had filed a reply, right? See, you can see it was coming from SCLC, so there was no monetary consideration for me as such, right? So the only purpose I did so that you can give a justice to the party, and court also knew. It was a beautiful court of Justice Vanirudh Bose and Justice Dhulia, who recognized this problem. And they said that, okay, we know our limitation that we cannot transfer, cannot ask wife to come. And even if we ask her, then this poor man has to give her to and fro. And I also put, I cannot give her charges for the lodging. Only to and fro, come and leave the same day by the night train or whatever it is. So they said that you use the VC thing. And the best part they did not ask husband to use the VC. They asked the wife to use the VC, and the court also realized that she is a poor woman, because generally the immediate thing which was taken by the other side was that she is a poor woman, she does not know how to operate the computer. She is an illiterate woman. So court directed the district authority. They all have this legal aid clinic. All the districts have. So they directed that they will be helping her do that. And if I had not filed a detailed response, then I would not have got this order and this man had to suffer. So the purpose of why I'm telling you for a TP also, because you get it as a problem in the paper 2 also for drafting. So this was actually a tip for your paper 2 also. Now, you have to also remember that when you draft for a transfer petition, right, what are the grounds that you are required to take, right? So first and most foremost is that where are the parties located, right? So there have been many cases coming, and there was yet another TP in which we were able to get favorable settlement for the husband because we were able to show that wife was working in Gurgaon and she filed the case in Lucknow only because her parents were located here. So we said that it is for the convenience of the party. So when you draft also, you have to rule out for the point of view of the convenience of the parties, right? So we said that if both the parties are working in NCR, then there is no point of transferring. So in that case also, transfer was total. So these are some of the cases which you need to remember, and invariably in paper 2 you will get a transfer petition to draft, right? So you have to show. अच्छा, generally wife की तरफ से आए तो you have to put only few things, that she is a woman. If relatively if somebody has to travel, the man should be travel because then second thing, you have to give the distance between the two places where the person has to go and seek the trial. If the couple has kids and kids are with wife, then that is the additional ground that you have to take. Then of course the medical grounds and the parents' health ground is another ground that you take. So this is just ancillary thing that I talk about on the jurisdiction, but this is very important from point of view of your paper 2 drafting. Now coming on to the criminal jurisdiction, right? You generally ask that you are not getting a fair trial from place A to place B. Then you are required to do that. Now court does not do it at the drop of the hat, right? So this is one more important thing that you need to understand. Just give me a minute. Sorry. So coming on to your criminal jurisdiction. So generally, if you look at the language, then it says about transfer of cases. But do you think even a FIR can be transferred from one state to another? Because it reflects very poorly when you are asking for transfer of investigation from one state to another. So the leading case which I suggest you to read, I think it is by Justice Rishikesh Roy in Sushant Rajput's case, where he had even allowed the transfer of FIR. Right? So this Riya Chakrabarti's case was there in Sushant Rajput's murder/suicide case. So you can just read it where the court has elaborated why they can have to transfer the jurisdiction. Now there have been cases coming whether Central Bureau of Investigation (CBI) is constituted under Delhi Police Act, right? This is one thing which you need to remember. So this is a body constituted under Delhi Police Special Act, Special Enactment Act, DPSC के अंदर है. So in this case, whether the other state high courts, can they transfer the investigation to CBI without the concurrence of the state government? Now, this is an actual question which has been asked and it came before the Supreme Court. So Supreme Court said that high court should not just transfer the case for the CBI investigation. They must do it in a limited case, but they are not required to take any sanction from state government for doing so. That way, it has maintained the independence of the courts also, but at the same time, they have said that you should have to do it very sparingly in very few cases. So this is another aspect. Then you have got Article 139A. Now, there are some cases where the matters are pending before various high courts. Now, either a party, usually the union, moves to the Supreme Court saying that these are the matters which are pending before the Supreme Court, kindly transfer it. So the category that will come is transferred cases. right? That will be the category coming. So there is an application. So if you look at various provisions of IBC were challenged under 226 in various high courts, right? And Supreme Court transferred all of them. Even if you look at the recent same-sex marriage, right? It was not necessarily pending before various court, but Supreme Court transferred all those matters to the Supreme Court for final adjudication. So that is the power with the Supreme Court that it can do so. So this is all about your transfer jurisdiction. Okay, then we come to the references to the Supreme Court jurisdiction. Now you have got a power under Article 317 of the Constitution, where if there is any if you have to transfer cases against UPSC members, right? Then reference can be made for removal of them if there is any misconduct against them. Then there are various references under various tribunals, under various statutes, like under your Income Tax Act, there are certain references which can be made to the which can be made directly to the Supreme Court. They are provided under the statute. So many statutes provide for statutory references, and those lies to the Supreme Court. Thereafter, we will come to very important provision, that is Article 143 of the Constitution, which is the advisory jurisdiction of the Supreme Court. Now, as far as the advisory jurisdiction of the Supreme Court is concerned, now it is a reference made by the President of India. President of India, he formulates a question and he sends it to the Registrar General of the Supreme Court. And they said that this is a question which has to be referred. Supreme Court issues notice to the Attorney General, and if there are states involved, if it is relevant, to the various states also. Now, then the important question that arises is, can Supreme Court refuses to give an opinion in the advisory jurisdiction? Can it say no to the president that this question does not merit any advice, and so we will not be giving you any advice on this? So the first time or maybe second time it was used, it was in the Ismail Faruqi case. At that point of the time, the government of the day, it asked about the opinion of the Supreme Court under Article 143 regarding your Babri Masjid, whether it is a disputed area or not, and all those questions it formulated. So court said that don't use your political plank before the court. This is not a fit case for giving advice. Right? So Supreme Court can even refuse to give us advice. Another question that you can get on advisory jurisdiction is whether it is binding on the other high courts, right? Whether it is binding on various high courts, the advice given by the Supreme Court under the advisory jurisdiction. See, what is the purpose of the court? The purpose of the court is to adjudicate, right? Only when there is some list, when there is something to adjudicate, it gives a decision on that. And that is binding under Article 141 of the Constitution, right? Now, in this case, the problem that arises is, this is not any dispute which is before the Supreme Court. This is just an advice which has given to the Supreme Court. So in this, the question which arose before the Supreme Court was whether it is binding on the various courts or not. So then again, they picked up the relevant article of the Constitution 144, and they said that whatever is declared by the Supreme Court is the law of the land. So even if there is an advice given on a particular topic by the Supreme Court in its advisory jurisdiction, then also it will be binding on the various courts, and it does have a precedential value. So these type of questions you can get as a 2-marker or a 3-marker, right? If they ask you to elaborate upon this thing, your advisory jurisdiction, then you have to start with that why 143, why only president can go and make this request to the Supreme Court only, right? And thereafter, we come to the elections of the president and vice president. Under the original jurisdiction, Supreme Court is the only court which has got the powers to adjudicate on the elections of the President of India as well as of the Vice President of India. There is the President and Vice President Elections Act of 1952. There it gives out various grounds on which it can be challenged. Now, at least it should be supported by 20 members of the electoral. There is a fee of, I think, 20,000. I'll just check it again. It is 20,000 only as the court fee that you have to deposit. And then court can adjudicate upon the election of the President of India or Vice President of India. Historically, if you see, there is these elections have always been challenged, right? Forget about last 3 or 4 past presidents that it has not been challenged as such. But earlier there was this man called Charanjit Lal Sahu, or popularly known as Dharti Pakad, if you have heard his name. Now, in this case, he used to challenge almost every election of every president of India. So this is all about your challenging the election of president or vice president of India. And now it is again based on very narrow grounds. Then, yeah, so this is, let me just check, I hope I have not forgotten any. So this is about your original jurisdiction.
These elections are given under which article? Elections to the president, vice president.
There is a separate act, right? There is a separate act for this president and vice president's election. I think this is Act of 1952, right?
But the powers don't emanate anywhere from the Constitution of India. No article would be.
No, under the Constitution of India also, you will have the relevant provisions for providing election of president and vice president of India. So, if you look at section Article 71 of the Constitution. Article 71 of the Constitution, it provides that all matters connected with the election of president or vice president, they are to be inquired into, right? It is only the Supreme Court which can inquire into, and it can be decided by the Supreme Court only, and the decision of Supreme Court will be final. So, it is the same chapter which governs the president and vice president of India. So, Article 71, you can take that. Now, thereafter, we move to the appellate jurisdiction of the Supreme Court of India. Now, when I talk to you about the appellate jurisdiction of Supreme Court of India, then there is I'll just share my screen again with you, right? So as far as the appellate jurisdiction is concerned, you have got civil appeals, criminal appeals, plus criminal appeals under enlargement of criminal appellate jurisdiction, extraordinary appellate jurisdiction under 136, special act. Then of course we will be taking the others. Now let us look first of all appellate jurisdiction under Article 132, 133 and 134 of the Constitution of India. Now, as far as your Article 132 of the Constitution is concerned, if you read it, right? If you read it, it provides that an appeal shall lie to the Supreme Court of India from any judgment, decree or final order of the High Court in the territory of India, where in a civil, criminal or other proceeding, if the High Court certifies under Article 134A that it is a case which involves substantial question of law as to the interpretation of Constitution. So what is the important thing? That Article 132, what does it say? It says that it requires, it can emanates from any order, any decree or any judgment or final order of any High Court if it requires any interpretation as to the constitutional provisions of the Constitution. So, substantial question of law as to interpretation of the Constitution of law is concerned. So, even against an interlocutory order, you can come under Article 132, provided that it raises a substantial order of court. A substantial, no, just a minute, wait. Sorry, under 132, it says against any judgment, decree, or final order. Sorry, 132 specifically says any final order. So only if it is a final order, judgment, or decree, then you can come against that before the Supreme Court. Now, there is this judgment of Muhammad Amin versus Dominion of India. This is an old decision of Federal Court, and it essentially lays down as to what do we mean by the final order of the court, right? So in this case, the court gave the four-pronged test that order decides that issue is vital. So many a times, even in the article for the interlocutory order, what seems to be an interlocutory orders, the court, the people have tried to come under Article 132 of the Constitution. Now, there is no bar that you cannot come against an order of a single judge, right? As we will see in the subsequent articles, that there is a bar that you cannot come against the order of a single judge of a high court. It has to be against the division bench or full bench. But there is no such bar under Article 132 of the Constitution. However, in case of R.D. Agarwala, the Supreme Court had said that though it is not provided, but propriety requires that single judge of a high court should not directly certify the matter to go to the Supreme Court, and it should go to the division bench. And one of the nice reasons they give that they get an opportunity to know opinion of one more court before them, before it comes to the Supreme Court for adjudication. Now,
ma'am, could you tell the judgment for the interlocutory order? If, ma'am, we can get that citations, because we don't get to need the, or you can put it in the chat box, ma'am, because the names sometimes are not clear.
Right. I'll just do the citation.
You can, ma'am, put it in the chat perhaps.
Yeah, I'll just do that. FC is Federal Court, okay?
FCS.
Only FC. Federal Court ka FC. And then one more.
And the name is, ma'am, Muhammad Amin.
1 second, you will find with this. The second one is Ramesh versus Seth Gendalal Patni. Second one is Ramesh, and first one is Muhammad Amin brothers versus the Dominion of India.
And what is the name of the second one?
Ramesh versus Seth Gendalal Motilal Patni.
And the R.D. Agarwala is the different one.
Yeah, R.D. Agarwala is the other one.
Okay, so ma'am, what
it was on the set? It was R.D. Agarwala. You can just write it down as 1971 SCC. I'll just put it in the chat box. Now, one very important thing you have to remember about Article 132, it says that if any order is coming from a civil, criminal, or other proceedings, right? So in that case, also you can come. Now, what do we mean by the other proceedings? Other proceedings can be your writ proceedings, because a chunk of litigation is coming through the
you are muted.
Sorry, this time is actually when some phones you cannot avoid because clients want. Some I am not picking up. Mostly I am not picking, but one or two I have to take. Now, as I was telling you, that 132 envisages not just civil or criminal, but other proceedings as well. So what do we mean by the other proceedings? Other proceedings would mean even your writ petitions, etc. You can come under, you can ask the court to give you a certificate for the same. Now, many a times a question is asked, is there any specific format for these certificates? So there is no specific format for these certificates. It is the High Court which says that it is, they think that this is a case which should go, and it issues a certificate. So there is no set, what do you call this, set format for issuing for these certificates. Now, one very important expression that had come under Article 132 is that it is regarding the substantial question of law as to interpretation of the Constitution. So, question that is can be asked to you, and it is asked many times, it is a repeated question as to what do you mean by substantial question of law. So, as far as the substantial question of law is concerned, so substantial question of law is that question which must involve law. It must be substantial in nature. Now, this is the word by word definition I'm giving you. But what do we mean by that? And for this, you have to read a judgment. I'm giving you the citation. It is the citation of this is 1962. You actually read this. This will actually help you in your practice also to understand that what is this judgment like. And remember the name of the case as Sir Chunilal Mehta versus Century Spinning Mills. Now, in this case, the Supreme Court laid down the test for determining whether a question is a substantial question of law. Because you said that it should be a question of law and it should be substantial in nature. What do we mean by that? So, in Sir Chunilal Mehta's case, the Supreme Court said that the proper test for determining the question of law raised is the substantial, would in our opinion will be whether it is of a general public importance or whether it is directly and substantially affects the rights of parties, and if so, whether it is either an open question in a sense that it is not finally settled in this court or by Privy Council or by the federal court, or it is not free from difficulty or call of discussions of alternative views. If the question is settled by the highest court or the general principles to be applied in determining the questions are settled, then these are merely the questions of applying those principles, or that the plea raised is palpably absurd, the question would not be substantial question of law. So what does Sir Chunilal Mehta's case say? That it should be something which is not settled by the Supreme Court. Right? At that time in 66, so they are talking about Privy Council and Federal Court, etc. So if it is something which is being substantially laid down, decided by the court, then it is not a substantial question of law. It is a question of law which requires only applications of the principle which are already being settled. Now, case in point that I can give you is that of marital rape. Right? It was decided from two-judge bench of Delhi High Court. It gave a split verdict in case of whether marital rape is a rape and wife can claim remedy against the husband or not. Now, this is a question which is not settled by any court, right? It is a question of a great general public importance, and hence it is a substantial question of law. So in my opinion, they should have referred it to the full bench so that Supreme Court could have one more opinion. But in their wisdom, they directly chose to issue a certificate and go to the Supreme Court. Now, there are large number of cases where the Supreme Court has denied that this is not a substantial question of law and the remedy does not lie in appeal under Article 132. Right? So there has been question as to interpretations of various provisions of income tax law. There has been questions which are related to rights of property of a person. This is not a substantial question of a law, right? Age of retirement of civil servants, what it should be, whether there should be prohibition in a particular state. So these all courts said that these are not the question of public great public importance, and hence they are not qualify as an appeal under Article 132 of the Constitution. So if you don't fall under 132, what do? You file a appeal, you file a special leave petition under Article 136, which is a discretionary jurisdiction of the Supreme Court. We will come to that also. Now, one very important thing that you are required to understand under Article 132 of the Constitution is that the party who is making the appeal, he or she should be party before the High Court. Now a question arose that the parties were not the original parties before the High Court, but they were subsequently impleaded, right? So in this case, whether they will be entitled to the for issuance of certificate and approach the Supreme Court under 132. So court said that they can approach the court under Article 132 of the Constitution. Why? Because this is a case where they were, once you are impleaded as a party, right? So even if you are not an original party, then also you contested it, and therefore you are entitled to appeal under Article 132 of the Constitution. So these are some of the issues which are regarding Article 132 of the question of law under Article 132. Now we move to Article 133 of the Constitution. Now, Article 133 of the Constitution deals with the appellate jurisdiction of Supreme Court in appeals from High Court in respect of civil matters. So, 132 was for interpretation of substantial question of law as to the provisions of the Constitution or to the interpretation of the Constitution. 133 is limited to the civil matter. Now, in this case, so I was talking to you about Article 133 of the Constitution, and it deals with the appeal to the in case of the civil matters. Now, it requires that if you look at Article 133 of the Constitution, it says that an appeal shall lie to the Supreme Court from any judgment, decree, or final order in a civil proceedings in a High Court if the case involves a substantial question of law of general importance, and in the opinion of the High Court, the said question requires to be decided by the Supreme Court. So in this case, it says that judgment, decree, or final order of the Supreme Court is important, where it requires to the interpretation of substantial question of law of general importance. So in this case, the case that you need to remember is Sal Narayan, S-A-L Narayan Rao versus Ishwar Bhagwan Das. So I'll just give you a citation. So Sal Narayan, 1966. Now, as far as your Sal Narayan is concerned, Sal Narayan, it lays down the test for determination of nature of proceedings in civil and criminal proceedings. So it identifies as to the whether the proceedings in civil or it is criminal in nature. And then the earlier decision which I spoke about of Ramesh versus Gendalal Motilal Patni. In this case, the court held that it is only those cases, right, where you require the interpretation as to the substantial question of law, or where it is of a general public interest of importance, only then the High Courts will issue a certificate. In Article 133, additionally, if the High Court feels that this is a case where they should refer it to the Supreme Court, right, it can do so. Now, under Article 133 of the 132 subclause 3 of Article 132, it provides that it does not lie from a judgment, order, or decree of a single judge. Single judge under civil proceedings is debarred from issuing a certificate. It is only in the division bench which can do so. But what we saw under Article 132 was that under 132 there was no such bar. Article 133 puts a specific bar that a single judge cannot issue a certificate under Article 133, that is in the cases relating to civil proceedings. Now thereafter we come to the question of, a question is asked whether other party can it challenge the right of High Court to issue a certificate. Suppose High Court has granted a certificate under Article 133 of the Constitution. Can the party can ask that if you cannot do so, sir, you don't have the power. So the Supreme Court said that even the maintainability of the same can be challenged. They can say that High Court was not competent to issue this certificate, and hence you should not hear the appeal. It is not that if the Supreme High Court has issued a certificate, it is mandatory for the Supreme Court to hear the appeal. So this is a very big thing that you can even challenge if the High Court says that it has no right to give the appellate. It is not a question of general public importance, right? So you can challenge that. So this is an important provision that you need to remember.
The other party's contention will be considered by way of statement of the statement of defense, as in reply of preliminary objections here.
Yeah, just where you file your counter. So by that way. Now, one very important question comes, like Supreme Court is the final adjudicator, right? So can you raise the question of law for the first time before the Supreme Court, whether it is under extraordinary original jurisdiction, extraordinary mein to ho gayi, under the appellate jurisdiction or extraordinary appellate jurisdiction, even in your SLP, can you raise a question of law for the very first time before the Supreme Court of India, which you have never raised before any forum before? So the court said that you can do so if there is any substantial question of law which has not been raised anywhere, right? So that can be raised before the Supreme Court for the very first time. However, on the question of facts, if it is a certificate granted under, say, Article 132, then Supreme Court will not go in the questions of fact. Otherwise, also Supreme Court does not go in the question of fact. But if it is particularly by way of appeal, then court will not go under the for the grant of certificate. Now, thereafter, you have got Article 134 of the Constitution, which deals with the criminal matter. Now, yeah.
Ma'am, I am not able to understand the fundamental difference between 132 and 133. Okay. Because 133(2) also says, 133 sub 2 also says that notwithstanding the fact of one, and the High Court may not consider it deem fit that it is to be referred, which is the second leg of 133 vis-a-vis 132.
Okay, I'll just explain.
Because if I just read
the fundamental difference. 132 ke andar you can raise any question, right? Okay. It can be civil, criminal, or other proceedings. The only criteria is it should raise a substantial question of law as to the interpretation of Constitution. Okay? Article 133, it deals only with civil questions, civil cases, where the question of law of a general public importance is the terminology used, right? Pehle mein substantial question as to interpretation of Constitution is required. Second ke andar civil, or civil ke andar bhi general question of general importance.
So if I have civil, if I have a civil case, the facts of the case are there, and it's a civil case. That is the facts. Now,
Right.
how would I determine it's a substantial question of law or general importance to come under 132 or 133? Is there any case law on this, ma'am?
No,
that it's a general importance or substantial question of law?
By constitutional interpretation, you want to go. Suppose there is something you wanted to deal with, say 377 ka tha. It requires ki this 377 of IPC, it is discriminatory under Article 14. So you require to interpret the constitution. Right?
Right.
Agar civil dispute and land, suppose you have to do for a land acquisition के बाद compensation pay करना है, right? So it will go before court or it should go before the collector, right? It is a question of great general importance. But वो constitution के नहीं आ रहा है, कोई particular statute जो आई थी आपकी right to fair compensation, you want to interpret under that. Suppose somebody wanted to get a notice issued, a certificate under that, right? So it will come under that, right?
So basically this is appellate, it will be civil appeal. So in both the cases, would it differentiate? It will be civil appeal only, no?
Civil appeal. It will be civil appeal और नीचे जो bracket में लिखा होगा under
article 132. उससे clear हो जाएगा.
Yeah.
But this is appellate civil jurisdiction. So SLP is different. 136 is different.
Right. Now we come to Article 134 of the Constitution. Now Article 134 deals with the appellate jurisdiction of the Supreme Court in regards to criminal matters. It says that an appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceedings of a High Court in the territory of India if the High Court has on appeal reversed an order of acquittal of an accused and sentenced him to death, or has withdrawn for trial before itself any case from any court subordinate to its authority, and has in such trial convicted the accused person and sentenced him to death, or it gets and certifies a certificate under 134A that this is a fit case for appeal in the Supreme Court. Now, it also gives a provision which says that this is subject to the rules formulated under Article 145 of the Constitution. What is formulated under Article 145 of the Constitution as the Supreme Court rules. Now, before I go any further, I would just like to explain you Article 134, at least the first part. So, 132 था आपका constitutional provision, 133 था आपका civil, और 134 है आपका criminal, right? So, in which there is an automatic appeal to the criminal this thing. First, agar order of acquittal by the trial court, it has been converted into an order of conviction and a person is given a death sentence. Second is the case where the High Court has drawn the proceedings from the trial court and taken it over itself and given a death sentence to a person. Then in such cases, it is a direct criminal appeal will lie to the Supreme. The third aspect, it says if the High Court itself issues a certificate that this is a case which requires a hearing by the Supreme Court, so please hear it. Now, it was realized that in many cases, it was the life conviction, life imprisonment which was given and not the death sentence. And so it was decided that a law called Enlargement of Criminal Appellate Jurisdiction of the Supreme Court 1970, it was formulated and it is only a 2-section act. It says that if these convictions are converted and from acquittal to life imprisonment, then in those cases, you can file a criminal appeal to the Supreme Court, right? So when we file these kinds of appeal, we don't file SLP. What we file is, we file a criminal appeal, but we file it under the criminal enlargement of criminal appellate jurisdiction. So this is the this is the things that you are remember. Now, one more important thing that you need to remember is the period of limitation for these is 60 days, right? For appeals is 60 days, for SLP it is 90 days. Now, because it is criminal appellate jurisdiction, then in criminal appellate jurisdiction, court, whenever it hears a criminal appeal, it will go into the facts as well as the legal issues, right? This is something which is essential. This is something which you need to understand very clearly, that as far as the criminal appellate jurisdiction is concerned, in this the court will go before, the court can go into the various aspects, including the including the questions of fact. Now, when we come to the next part of appeals, there are large number of statutory appeals which are provided under the Act, under the various statutes. Some of them are provided under the Central Excise Act, which was there. Then there are some which are provided under Advocates Act. Then there are some provided under the Consumer Protection Act. Then you have got statutory appeals under your NCLT, under your NGT, right? So these are the type of the cases that you must be aware that are coming to the Supreme Court. Now with this, we move to our own bread and butter. Article 136 of the Constitution, which is a special leave petition. Now, this is an extraordinary appellate jurisdiction. This is a jurisdiction which is provided to the citizens to get a final approval, right, from the Supreme Court, to get a final chance to put before their case before the Supreme Court. Now, if you read Article 136, it provides that notwithstanding anything in this chapter, the Supreme Court in its discretion grants special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court, tribunal or territory in India. So this is vast. This is like an ocean, right? This is like, even if it is an order of magistrate, you can challenge before the Supreme Court, right, under 136. Of course, it will entertain or not entertain, it's different, it's discretion. But if you looked under 132, 133, 134, it was from the High Court that it was coming. But in case of 136, it can be any order, it can be any order, judgment, decree, determination, sentence, anything, right? You can come against that in Article 136 of the Constitution of India. So the scope of Article 136 is immense, but it is one which is used very sparingly by the Supreme Court. At one point of a time, 99% of SLPs were dismissed. Now around 90% SLPs till a decade back were dismissed, and today this proportion has increased for some good. So around 70 to 80% of SLPs are dismissed and rest are admitted. So if you look typical at the working of the Supreme Court, Mondays and Fridays, which we called in our Supreme Court parlance as the miscellaneous days. So these are days when the fresh special leave petitions are listed. Usually each court has around 60 cases, and now even we have 17 courts, but even if you take 15 of them, so you can do your maths, 15 into 60. Now around 900 cases are listed every day every Monday and Friday before the Supreme Court, right? Under Article 136, under various statutory appeals, and 90%, 80% of them are dismissed, right? So 136 is a very, very wide discretion of the Supreme Court. Now, there is an important case that I would like you to remember. I just give you citation of the same to discuss the scope of Article 136. This is 1950 SCR 453. This is case of Preetham Sen. Now, this is Preetham Singh is the first case where Supreme Court discussed the powers and the scope of Article 136. So it says that Supreme Court has got wide discretionary power to decide upon the scope of 136. It is essentially what Supreme Court feels that it has a right to interfere in the impugned order before it. Whether it is an order where it should think that it should interfere under its vast discretionary power. Now, there have been attempts made by the legislature to take away the powers of the Supreme Court under Article 136. This was done under the Industrial Disputes Act also. And court said that this is a discretion of the Supreme Court, and a person can move Supreme Court under Article 136. So under Industrial Disputes Act, under the Representation of People's Act, there were various provisions which said that whatever is the decision of the tribunal, it will be final, right? It cannot be appealed further. It will be final and conclusive. And these things were said by Supreme Court that you cannot take away the power of the Supreme Court under Article 136. Now, there was an interesting case in which the tenant has given an undertaking that he will vacate the premises within 1 month. So he came in an SLP before the Supreme Court, and the question which came before the Supreme Court was whether the tenant has a right to file an appeal, particularly when he has given file a SLP, particularly when he has given an undertaking before the court. So in this case, the court held that it has got a right to prefer special leave petition. Now, essentially, if you look, there are only two tests for whether an application for the jurisdiction under Article 136 can be invoked. First and foremost, that it must be from any judgment, decree, order, determination, or sentence of any court. It can against that you can come to the court. You cannot come under Article 136 against any executive, purely an executive or an administrative order, right? So if the order or the determination giving rise to appeal is judicial or quasi-judicial, right, then you can come under it. Second thing is, it must be made by any court or tribunal in the territory of India, right? If these conditions are satisfied, then Article 136 can be invoked.
So, ma'am, if I file an SLP from a trial court order, from a ADJ order,
right,
and it gets dismissed, so then I can always take my normal route of civil appeal, going to the High Court, then going to the
LPA, but then one very important thing, right? In such case, always withdraw your petition. Don't let it get dismissed, because then sometimes the question of res judicata, constructive res judicata, etc., that can be invoked, right?
So we generally say, yes, I wish to withdraw it with the liberty to
always, whenever you withdraw it with liberty. Take it as a rule of thumb that whatever you have to withdraw with the liberty.
So and liberty is also discretion. Sometimes they don't grant liberty also. Sometimes
they don't grant. They say you do whatever you want to do.
Okay.
Now, one very important thing is your doctrine of merger that I want to explain to you. Now, this is very important for anybody who is working in the Supreme Court or somebody who wants to work in the Supreme Court to understand. So, as far as your SLP is concerned, suppose we are challenging one High Court order, right? in any list, there can be finally only one order. Suppose there is an order you challenge before the Supreme Court, and Supreme Court dismisses it in limine, which it does usually dismiss. That is only one word written. Or sometimes they write, we don't want to interfere with the high judgment of the Supreme Court, and hence we are dismissing this special leave petition. So what happens to the decision? Which is the binding decision? So if the SLP is dismissed in limine, then the binding decision is that of the High Court, right? The impugned decision. But if the special leave petition is allowed, your notice is issued, other parties come. So if you read any judgment, first thing you will return is leave granted. Leave granted का क्या मतलब है? Leave granted means you have been given the leave is granted to file the appeal. So your SLP number will change to a civil appeal or a criminal appeal, right? So once that leave is granted to you, under that leave, the court will give its judgment. Now, whatever the judgment is, that judgment and the High Court judgment, it merges. The High Court judgment merged with this decision of the Supreme Court. And this is the only decision which will be applicable, right? So with this, we will just conclude our today's session. Tomorrow, in the next class, that will be on 26th, right? On 26th, we will be covering the remaining part of the jurisdiction of the Supreme Court, that is your curative, your review petition, and your contempt jurisdiction of the Supreme Court. And then we will have a look at the Supreme Court rules also, right? And then 28th class, I will be shifting to 27. Okay, that is the class that I will be shifting, because 28th I will be traveling.
Ma'am, जो ये last वाला है ना, doctrine में both the judgments will be merged. So if SLP is reverses the High Court order.
हाई कोर्ट का जो भी ऑर्डर है, मान लो आपको एक्विट करा, सुप्रीम कोर्ट ने भी आपको एक्विट कर दिया, तो दो ऑर्डर तो नहीं रहेंगे. तो हाई कोर्ट का ऑर्डर इट मर्जेस विद द सुप्रीम कोर्ट. सो व्हाटएवर इज द ऑर्डर पास्ड बाय द सुप्रीम कोर्ट विल बी देन फाइनल ऑर्डर.
That will be the binding order.
राइट. और अगर डिसमिस इन लिमिनी है, एक ही वर्ड में कहा डिसमिस, तो जो हाई कोर्ट का ऑर्डर है, रीजनड ऑर्डर है, दैट इज द बाइंडिंग ऑर्डर, बिकॉज उसमें तो आपकी कोई रीजनिंग आई नहीं.
Right. As in when it listens and issues notice, then it is called as disposed of, if I'm not wrong.
नहीं, क्या कह रहे हैं? Just come again.
अगर dismiss नहीं हुआ, leave grant कर दी मुझे,
leave grant कर दी, then it will give leave grant करके, then it will go in the due course. Leave grant करके वो आपको उसी का उसी समय सुन के आपको they can give a decision also, or it can come in due course. So if you see the decisions order, in case where leave is granted in 2008, 2009. These are the matters which are coming as a regular matters now in the Supreme Court, which are coming for the final year. Right? SLP is immediate disposal is there.
Okay. Acha, if you say if it is dismissed, then it is dismissed in limine. If it allows,
dismiss means gone. It is
gone. And if he allows that SLP, then it gets combined. Is what you are saying?
Yeah. If it allows, or then other party will give reply, you will give rejoinder. There will be a court will hear, it will give a detailed judgment. Right? So it can come in due course or even without coming in a due course.
When it listens and gives the detailed judgment, then it can go in my favor and it can go against me also.
True,
right?
true.
So it is referred to as disposed of. If I am not right.
Yeah.
Thank you, ma'am.
Okay. See you day after tomorrow on 26th, and instead of 28th, I will be taking on 27th.
Thank you, ma'am.